5, 4, 3, 2, 1. This revision is directed against an order of the first civil and sessions judge by which he dismissed the revision filed against the trial court's order refusing to discharge the accused on his plea that the prosecution could not legally proceed. A complaint was filed by the income tax officer for an offence under section 277 of the Income Tax Act, hereinafter to be referred to as the Act. The complaint made the allegation that for the assessment year 1963-64, the accused had filed a return in which he had concealed the particulars of his income. The summonses were issued to the accused, but before the charge was framed, an objection was taken to the further proceeding of the trial in view of Section 279 of the Act. It was urged that the complaint had not been filed at the instance of the Commissioner and that the case could not proceed against the accused in view of the penalty being waived within the meaning of Section 279 1A of the Act. The contentions were not accepted by the magistrate and the first civil and sessions judge dismissed the revision. Certified copy of the judgment of the tribunal in the appeal arising out of the penalty proceeding and of the appellate assistant commissioner of income tax dismissing the appeal against the original assessment order as infructuous have been filed as additional evidence in this court. The facts leading to the case as have finally emerged out are the following. A particular income was returned by the assessees. The income tax officer found that the return was not correct and hence completed the assessment at a higher figure. He was further of the opinion that penalty was impossible under section 271 1C of the Act, but as the amount of penalty had to be greater than rupees 1000, he referred the matter to the inspecting assistant commissioner of income tax. The inspecting assistant commissioner imposed a penalty. Against that order, an appeal was preferred before the tribunal. The tribunal allowed the appeal and set aside the order imposing the penalty. The income tax officer issued notice tender section 147 and made a supplementary assessment for the escaped income. The income tax appellate tribunal set aside that assessment and remanded the case to the income tax officer for fresh consideration after giving opportunity of leading evidence to the assessees. With respect to the original assessment, the assessee filed an appeal before the appellate assistant commissioner of income tax. That appeal was dismissed as infructuous. The appellate assistant commissioner appears to have thought that the appeal had become infructuous because of the order of the income tax appellate tribunal passed in appeal arising out of the supplementary assessment by the income tax officer under section 147 of the Act. The effect of the various orders is that the appeal against the original assessment has been dismissed as infructuous. The case under section 147 of the Act has been remanded to the assessing authority by income tax appellate tribunal and the penalty imposed on the basis of original assessment has been set aside. On the basis of these facts, it has to be seen whether the prosecution can continue or it has to be quashed. According to subsection 1, a person can be proceeded against for an offence under section 277 only at the instance of the commissioner. The evidence produced in the case shows that the Commissioner had authorized the prosecution. Learned Counsel contended that in Section 279(1)(a), the words waived by an order under subsection 4(a) of the section should be read as cancelled by an order of the Income Tax Appellate Tribunal, as this is the intention of the law. When the words of a provision of law are specific and clear, it is not open to a court to go behind the section to discover the intention of the legislature. The acceptance of the contention of the learned counsel will mean not interpretation but legislation, in the sense that another condition will be deemed to be added in subsection 1a of section 279 to the effect that a person shall not be proceeded against for an offence under section 277, provided the penalty imposed is subsequently cancelled by an appellate authority. Waiver and cancellation being two things, the reading of additional condition will be foreign to the existing provision. The same cannot therefore be read as implied in the section. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.